Again to another episode of Scott Talks Law. So in this episode we are going to talk about the fundamental principles of non-refoulement. So the non-refoulement principle is the principle that prevents returning refugees to the area where the initial state where they faced persecution. So we are going to look at the application of this principle of non-refoulement, the various legal provisions that govern this doctrine of non-refoulement or the principle of non-refoulement, and we are going also to look at the various case laws that governs the principle of non-refoulement. So the history of this. So refoulement, first of all, is the act of returning asylum seekers to areas where they came from. You are denying them asylum. So the history of this non-refoulement principle arises out of the international collective memory of the failure of the nations during World War II to provide safe haven for refugees who fled certain genocide of the Nazi regime under Germany. So it has got the history from the genocide of Rwanda, the Rwandan genocide. This is the German genocide. The German genocide under the leadership of Adolf Hitler. So after the World War II, there was no protection to during World War II, there was no protection to people who are fleeing from Germany, seeking protection to other countries. So this non-refoulement principle arose or came out after the World War II. So the main legal provision is the 1951 Convention, and refoulement is provided for under Article 33 sub-Article 1 and 33 sub-Article 2 of the 1951 United Nations Convention. So that, according to that convention, has brought about the concept of non-refoulement into a public disclosure. So it has under-disclosed non-refoulement in details, and the protection under the Article 33 sub-Article 1, Article 33 sub-Article 1 provides for the non-refoulement, and 33 sub-Article 2 provides for the exemptions to this non-refoulement principle. So Article 33 sub-Article 1 applies to any person who is a refugee under the terms of the 1951 Convention who meet the definition enforced in Article 1A sub-Article 2 of the Convention. So if you meet that definition of being persecuted on grounds of race, on grounds of gender, on grounds of nationality, on the grounds of color, on grounds of belonging to a particular social group, and you've got that well-founded fear in you, and because of those well-founded fear, because of the persecution, you are unable or unwilling to return to a country of nationality, then you meet the qualification of being granted asylum, and you are not supposed to be refoulement or to be returned, to be extradited, to be returned to your country of initial country, but you're supposed to be contained and given, provided for the asylum that you are seeking for. So the principle has become recognized as a cornerstone of international refugee law, and has achieved the status of non-derogable rights of a person fleeing for protection. So it has gained that status. It has become a cornerstone according to the United Nations Human Rights Commission. They describe this right as a cornerstone. They refer to it as a cornerstone of all rights, and for any person who is fleeing from protection. The principle is also embedded in other legal frameworks, e.g. the international human rights law, the international humanitarian law, the customary international law. So the application to the internally displaced person has also an added significance. So it also applies to IDPs, the internally displaced person, that they can also seek protection to other countries, and they are not supposed to be returned to the initial country. So the prohibition of refoulement is applicable to any forcible removal to deportation, to extradition, to non-admission at the border, and to internal transfer, and evidence from Article 33 sub-article 1 of the 1951 Convention. So those are just evidences of non-refoulement, being extradited, evidence of refoulement. So refoulement is prohibited, and refoulement can be done through those acts that I've described, that I've mentioned to you. And they include extradition, they include deportation, they include expulsion, they exclude forcible removal, and among others. So we've got exemptions to this principle of non-refoulement under Article 33 sub-article 2 of the 1951 Conventions of Refugees, and this includes being a threat to the national security of that particular country, and when you have been convicted for a term, for a serious offense. So permitted circumstances provided under Article 33 sub-article 2 include danger to the security of the country, having been convicted by a final judgment of a particularly serious crime that constitutes to danger of the community of that country. So the legal provisions here, the laws applicable, include the Constitution of Kenya 2010 and Article 2 sub-article 5 and Article 2 sub-article 6. And according to Article 2 sub-article 5, any international conventions shall form parts of the laws of Kenya, international laws shall form parts of the laws of Kenya, and Article 2 sub-article 6, any treaty or ratified, any treaty or convention shall also form part of the laws of Kenya. So you also have the 1951 UN Convention, Article 33 sub-article 1 and 33 sub-article 2 of the same. And we also have the Convention Against Torture and Other Cruel and Inhumane Degrading Treatment or Punishment, 1987. And Article 33 sub-article 1, no state party shall be expelled or returned or extradited a person to another state where they have been subjected to torture. So we also have the American Convention on Human Rights, 1969. We also have the International Convention for the Protection of all persons from enforceable disappearance. We also have the Geneva Convention 1949, or the OAU Convention 1969, the Refugees Act of 2006, the Refugee Bill of 2009. So those are the legal provisions. And we also have the case laws here. The case laws here include the Kenya National Commission on Human Rights versus Attorney General. And according to this case, there was that press statement that was that wanted to close the refugee camps in Kenya of Kakuma and Dadaab. So they wanted to close these camps because they were claiming that refugees were becoming a threat to the national security, and it went against that principle of non-refoulement. So there's that statement by Dr. Karanja Kibicho, and issued a statement on the closure of camps owing to national security. Hosting refugee has come to an end, and the government is working on a mechanism of closure of the two refugees camps with the shortest time possible. So we've got also challenges with this principle of non-refoulement, and the challenges here, there's no adherence to this principle because we've got forcible repatriations by states, as you've seen that in that case of Attorney General versus Commissioner on Human Rights, the Human Rights Commission versus the Attorney General. So you can go and look at this principle of non-refoulement in detail, because that is just you can just go and look at it in detail because it's a key principle under refugee law. So that's the end, and come on, you guys, we gotta do this.